right, why are you winking at me? You winked from the side. Here's the thing. Here's the thing. We are not on that level. So don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right, you want to take him?
Take them.
Yeah. All right. I don't understand. Why are people winking at me? We're not on that level. Mr. Escobedo, is the court's understanding based upon the council's motion to the withdrawal, you want to hire an attorney? All right, you have 2 weeks to get an attorney. If not, this will be your attorney. And you can speak to him or not speak to him. That's completely up to you. If you go to trial, you will go to a trial with an attorney you have not spoken to. But he's been your attorney since April. So 2 weeks, you need to have your new attorney here if you're planning on hiring one. Ms. Ferguson, I need a 2-week reset.
July 29th.
And state
Yes.
and defense, do you have all of the discovery?
Yes, Judge.
All right, if you can do an acknowledgement of discovery for me, the system's down.
It is.
So it's down. Were you able to tender an offer?
Not today, but I can get one.
All right. All right, so if you'll tender an offer today and July 30th, I'm sorry, July 29th will also be your plea deadline date. All right, once you sign the reset form, you're excused.
Okay.
All right, and they will give you an offer, counsel. Yes. And Mr. Escobedo, you need to be on time for court next time. Do you understand? All right, let me just tell you, the other courtroom you were in, was it a district court? All right.
Come up so you can tell me to get that.
Sylvia Noriega. Who's the attorney for Sylvia Noriega?
Hey, so Mr. Glitter.
All right. All right, why are you winking at me? You winked from the side. Here's the thing. Here's the thing. We are not on that level. So don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right, you want to take him?
Take them.
Yeah. All right, I don't understand. Why are people winking at me? We're not on that level. All right, Sylvia Noriega? Yes.
This was a motion to adjudicate that was set a couple of weeks ago.
Mhm.
We set it to see if any of the restitution had gone to the alleged victim.
Yes.
And that's where we are now. She's been on deferred, I believe, for about 10 years.
So were you able to pay any restitution?
Well, I haven't paid any money yet because I was waiting to see what was gonna happen.
You have a motion to revoke because you haven't paid any restitution. What's going to happen is if you don't pay restitution, and it appears based upon what you've told me that you have money to pay restitution, but you're trying to see what's going to happen and hedge your bets. So we can go forward on the motion. Do you want to go forward on the motion to revoke today, counsel?
No, Judge, I think the issue is she's paid restitution, but we don't know regarding the probation, all the restitution has gone to the alleged victim or if it's going to probation. I think that's what the issue was the last time we were in court. to figure it
Right.
out. Unfortunately, today, because the system is down, probation's unable to look at information.
Are you able to come back this afternoon?
What time?
We can have her back at 1:30 and we can see if the systems are up.
Would I be able to do it by Zoom or would you? need
Yes,
in
you can do it by Zoom. Well, you know what, let's not say 1:30 because we have trial that starts at 1:30. The main, I tell you what, we'll recall it for tomorrow and for restitution issues. And if your client wants to appear by Zoom, she can appear by Zoom because it's a matter of restitution. And then if there's an issue, we can always reset it for a contested MTR if that's what needs to be done. All right?
It's fine, thank you.
All right, so make sure though that you save some money in case they say that you owe restitution, okay?
Yes, ma'am.
All right, do you have any questions about anything? Thank you for dressing appropriately for court and being on time. All right, once you sign the reset form, you're excused. I'm like, oh, just tell me what the case is. Sorry, what's the name? Raycon Fields. Let me see what page it. All right, let me see what page he's on. Okay. And transferred where?
To 227. It's co-defendant's case is there.
All right. Thank you. And just let Deputy Laura know.
Thanks, Judge.
You're welcome. All right, who's here on David Wayne Huff?
I am, Your Honor. I'm ready with an MTR with the agreement.
Okay.
Are you ready for it, Judge?
Yes.
I think that's it.
Oh, Waycon Fields, they say they're being transferred to the 227. And it's on page 6. Sure. Bye.
Good morning.
So are they seeking to withdraw this?
No, Your Honor, we're going to plead true with an agreement to continue on probation. With the evaluations to be done in custody.
And is this a misdemeanor assault?
It is a non-family misdemeanor assault, Your Honor. And there's already an agreement in place. I'm not the lawyer on that case, but there's an agreement to dispose of that case.
And what's the agreement on that case?
90 days to do. He will have probably racked up enough time by the time he's in custody. Getting done his obligations on probation.
All right, so you understand, if you have an agreement with the state of defense, I don't have to follow that agreement. You understand that? All right. Court is calling 2025 CR 003649 State versus David Wayne Huff. Can I have parties announced?
Deputy Clerk of the State of Texas, Your Honor.
Matthew Finch for David Huff, Your Honor, ready?
And are you Mr. Huff?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
All right. Are you the same David Wayne Huff who was placed on community supervision in 2025 CR 003649 for the offense of possession of a controlled substance, penalty group 1B NA? It's in a drug-free zone on May 15, 2025 for a term of 6 years. All right, state.
Violation of condition number 1, on or about the 16th day of May 2025 in Bear County, Texas, the defendant, David Wayne Huff, committed the offense of assault in violation of condition number 1.
All right, and how do you plead?
True.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes,
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is to continue probationer on probation, but to allow for all the evaluations that have not yet been complete to be completed while in custody. The state understands that there is a proposed agreement as to what will happen with the assault that defendant has just pledged true to. So continuing probation will have everything, all the cases will be taken care of, and the state believes that probationer will be able to start a successful probation journey. Your Honor.
All right, sure. And that's the agreement, counsel?
It is, Your Honor.
You want to raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you'll state your name for the record.
David Wayne Huff.
All right, so Mr. Huff, they're saying that they want certain evaluations done in custody. I see that you were placed on probation in May. So why did you not follow through with those evaluations out of custody?
I was only on probation 8 hours.
I'm sorry?
8 hours.
Yes, so what happened?
Okay, so
So you 8 hours and then this incident is alleged to have occurred?
To maybe shortcut, Judge, he went home. There were some people living in his home that he was trying to get out of his home. An altercation happened. It was people that were trying to get him to use drugs, Judge. And he was trying to do the right thing. He told me this story and told several people that story, but he was trying to fix the problem so he could be successful, and here we are. And he's been in custody since.
Okay. It explains things.
yes, ma'am.
Now I understand why I should follow your agreement. All right, this is what the court is going to do. The court, as previously stated, is finding violation of condition number 1 true. The court will alter and amend conditions to the following, and this is to happen in custody. A TAP evaluation and a referral to felony drug court. And I am going to order, I think somebody's already ordered you to have 120 sober meetings in 120 days. Was that previously ordered?
It was, Judge.
All right. So you're to make sure that you do that. If for some reason, because the systems are down, if some reason they release you from the Bear County Jail, you know you're not supposed to be released, right?
Yes, ma'am.
If for some reason they release you, don't fight them over it. Just come back to this court in the morning, okay?
Yes, ma'am.
All right, do you have any questions about anything?
No, ma'am, thank you.
All right, is there anything else you need from the court?
No, ma'am, I'll be successful.
All right, if in this court to be successful on probation, communication is key, right?
Yes, ma'am.
So if you need something, let probation know. If they feel like they're not addressing it, you can always come back to the court. CR 009634, State versus Baldemaro, Joseph Chapa. Can I have parties announced?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa.
All right, this hearing was scheduled at 9 a.m. It is now 9:56 a.m. The defendant has not made an appearance. State.
The state would ask the court to issue a warrant.
All right, counsel, have you had any contact with Mr. Chapa?
Not this morning, and he has been communicative with me up until today.
All right, the court will grant the motion, remain your client without bond. If your client makes an appearance, the court will reconsider.
Yes, ma'am.
So if you want to see if you can get in touch with him before the day is out, just let the court know.
Yes, ma'am.
All right, thank you.
Thank you, Judge.
All right, I'm going to take up Jesse Garcia. Then after that, it will be Marco Marino. Thank you. Thank you for your patience. All right. Hi, who's here on Jesse Garcia? Hi, where's Mr. Garcia? Nobody wants to come forward anymore. How's it going? Yeah. I can't complain. System's down. Defendant winking at me. I don't know what's going on. All right. So you are scheduled for a jury trial. We're currently in a jury trial. It may be completed today. So I'm going to recall you.
Hold on.
Yes.
In case the victim didn't show up, I had deputy make an announcement, I seem to confirm when she comes back in.
Okay.
Victim didn't appear, state will announce dismissal, this one have the dismissal.
All right. And the court will note for the record that the court was tendered an affidavit of non-prosecution as well.
Yes.
And it is scheduled for jury trial today. All right, Mr. Garcia. All right, let me just tell you, they're dismissing this. They're saying that the complainant has waived prosecution. Whatever issues there are that are occurring, you need to make sure those are corrected, because otherwise you're going to be right back here. You understand?
I understand, Your Honor.
I will always tell people, if you get to a point in a relationship where you want to get violent with somebody or put your hands on someone and anything else than love, then maybe you shouldn't be in that relationship. You understand?
Thank you, Your Honor.
All right. Good luck to you.
Thank you.
You're welcome. Thank you, counsel. Yes. All right, Marco Moreno. And state, on this case, do you have your file with the plea that you entered into? Do you have the plea page on this case? Yes.
Yes, Your
All right, if I could have a copy of that, please.
Honor, it's my personal copy, obviously it's not working with me.
I'm sorry.
Obviously, it's not working with me this morning.
Yeah, it's.
Does I have a hard copy? I can
Oh,
look at it.
yes, thank you.
Oh, perfect.
Okay, so Christine was ready for Odyssey to break down. Nobody else was ready. She was ready.
Well, I have a personal copy.
Okay. All right, you may proceed, counsel.
Ms. Medina, what is your relationship to Marco Moreno?
Marco Moreno is my brother,
And are you his older sister or younger sister?
older.
And how would you describe your relationship with Marco?
I would describe it as a really good relationship.
And what examples could you give of how you have a really good relationship?
We would talk in the phone even if we didn't see each other very often, but even when I lived in Atlanta, Georgia, we would call from time to time. We would just text to see how we were doing. And after we moved here on weekends, most of the weekends, we would meet up at my mother's house and just to visit, sit there, talk, and just hang out in my mom's house.
And so where is your mother's house?
She lives in 2618 West Trail,
All right, what city?
San Antonio.
And what is your relationship to the victim in this case?
To the victim in this case, she was, I considered her like my step niece,
And why would you say Stephanie's?
because I felt like sometimes she opened up to me and I saw her like that, like a niece.
All right, and so how often would you interact with this family, including your brother and the victim in this case?
From time to time, maybe once a month. My brother was more often, and as well as his children, but with the victim in this case would be from time to time, every now and then, even when I lived in Georgia, sometimes I would text her.
I'm sorry, could you keep your voice up just a little bit for me?
Yes, ma'am.
All right, you may proceed.
Yes.
And so what was the extent of your interactions with the victim and her family while this case was pending?
Well, I went to visit probably twice. Once, it was almost after my brother Marco Moreno was arrested.
And what were your observations during those times?
My observations, well, within the home was filthy. The home was filthy and
How would you
Your Honor, I'm
describe
gonna
that?
object to relevance.
Judge, may I respond?
Yes.
So the Article 42A102 of the Texas Code of Criminal Procedure allows a judge to place a defendant on deferred adjudication for this offense. But what must be considered is that this would be in the best interest of the victim. We are going into a discussion that we believe would assist the court in making that determination.
All right, the objection would be overruled.
yes, the home was dirty. It was messy. That's what I noticed.
What do you mean by dirty or messy?
There was things all over the place, including the floor, the table. There was hardly anywhere to sit.
And what do you mean by hardly anywhere to sit?
There was things all over the place, all over, like, items.
How many children were in that home?
From what I saw, it was my niece and nephew,
How old are they?
6 and 9.
And who else was in that home the last time you were there?
There was a man that opened the door, or he opened the door, and then when he saw us, he shut the door, immediately shut the door. And so I don't know, I've never seen him.
So after that interaction with that man, what happened?
After that interaction, well, he shut the door, and then we continued knocking until the victim's mother came to open the door.
All right. And then without saying names, how did that interaction proceed from there?
Well, that interaction proceeded where
Well, what did you learn from that interaction?
the victim's mother was saying that
Objection to hearsay, Your Honor.
Sustain.
she was saying
Excuse me,
Counseling.
You're not allowed to repeat what other people have said. All right, so when either party makes an objection, I'm gonna make a ruling. If you don't understand my ruling, just let me know. You can say, do I still continue to answer or not? Okay.
Sorry. Yes,
No,
ma'am.
no problem. So in that situation, you're not allowed to say what anyone said. You understand?
Yes.
All right, so that objection will be sustained.
And so without going into what anyone has said or told you, what was your understanding of the family dynamics based on your observations and interactions?
The family dynamics to me is it's I don't feel like it's a good situation there.
Why is it not a good situation there?
Based from what I saw, I feel that no children should be staying in a filthy house.
And to your knowledge, who was supervising these children, to include the victim and the
To my knowledge, a lot of times the victim was supervising the children.
and how old is the victim?
The victim, now she is 16.
How old was she when you had personal knowledge or observations of this?
She must have been about 14, 15 years old.
And just to be clear, how long have you known the victim?
It has been probably 6 to 7 years.
Right. And so I want to talk more about your brother. What assurances could you provide this court if his application for deferred adjudication were approved, that he has a foundation to be successful on deferred adjudication?
Well, I would, on my behalf, I would call him and go to where he would be staying. I would call him and make sure that he is following up and keep track of his, if he has any appointments with his officers or anything, I would keep up with that, find out, put it on my calendar if I have to, give him a call. And if I'm able to, I'll take him myself because I want him to succeed, and I know he will.
Okay.
And where would he be staying if he were released?
He will be staying at my mother's house at 2618 Fitzgerald, here in San Antonio.
And what more would you like the court to know with regard to his application?
I know he is. I know I know he's learned his lesson. I know he's a hard worker. And, he has a lot of support at home. He does. He has a lot of support. We will all keep an eye on them and make sure that he follows through. And I know he will.
Nothing further.
All right, state.
Yes, ma'am. Good afternoon, good morning.
Good morning.
Ms. Endes. So you're the defendant's sister?
Yes, ma'am.
Okay. And his older sister, do you have any children of your own?
Yes, I do.
What are their ages?
They range anywhere from 22 to 36. 37, sorry.
Do you have any grandchildren?
Yes, I do. I have 6 grandchildren, 1 great grandchild.
Congratulations.
Thank you.
What are the age ranges for the 6 grandchildren?
The ages are almost a 2-year-old all the way to a 21-year-old.
And what about your great grandchild?
He's
3?
Yes.
And I think he said it's the little boy.
Yes.
All right. And I want to talk about you're here today. How do you know about, or what do you know of this offense? What do you think happened?
What do I think happened?
Mhm.
I think, I'm gonna be 100% honest. I feel like they wanted to get him out of the house, so he doesn't have contact with the children.
So you don't believe he did this at all?
No.
And so then you, not believing that he did this at all, you wouldn't have any concerns about bringing your children, grandchildren,
No.
great grandchild around him? Okay. Any further questions, Your Honor?
All right. Any other questions?
Yes, just briefly.
Sure.
And Mr. Sendiz, I understand that this may be a very difficult question for me to ask, but it relates to what the state has asked you. As it pertains to child abuse and the topic of child sexual abuse, what personal experiences have you had?
Objection to relevance, Your Honor.
Overruled.
Thank you.
Yes, you can proceed.
I have personally, my oldest daughter, when she was 13, she was beat and abused, sexually abused. So for me, if I knew my brother was guilty, I wouldn't have supported him because I know how that feels.
All right. So here's the thing. I want to thank you so much for giving me some insight into your brother. And I understand that sometimes when relatives come to testify, people want them to say that they believe this is true, right? And if you don't believe it's true, that's fine. And I'm not going to hold it against your brother that you don't believe it's true.
Right.
So I want you to know that when people come and testify, all I want them to do is tell the truth.
Yes.
And when you tell the truth, it doesn't negatively impact your brother. So the fact that you don't believe that he didn't commit this offense, that's not going to negatively impact him. I'm just trying to get some insight about him through the witnesses that are called so that I can make an appropriate decision in this case. Okay?
Yes, ma'am.
All right. Is there anything else?
Nothing further.
Anything
Nothing
else?
further.
All right. Thank you so much for
Thank
coming
you.
in. All right. Next witness.
Yes, at this time, the defense calls Juan Moreno to testify.
All right. Could we let me just take a short recess so I can take up a couple of more cases and then I'll continue.
Thank you.
All right. Thank you so much. Jesse Orozco. Hello.
Hi, Your Honor.
Hi.
Oh, I love you. That dress, pretty.
Oh, well, thank you very much. I'll let my mom know you said so.
Kind of a Longhorn thing. I'm not gonna say, I'm not going there. Not
Hey,
going there.
hey, now. You were going so well. Now you just,
Hey, I couldn't help myself.
that's okay. All right, on this case, have you received all discovery?
Yes, Your Honor. We are, asking for a reset. He is in recovery right now, and
Mhm.
I'm trying to gather some documents evidencing that, and, I'm gonna confer with the DA, and also need to look at the, videos. I've not had opportunity to review those, but I see them on my discovery that they're there, so.
All right. So what I'll do, since you're still looking at videos, I'm just gonna set it for a discovery date.
Okay.
Another discovery date. And at the next date, the state is gonna have to be prepared to tender an offer.
Okay.
All right.
All right.
Ms. Ferguson, I need a 30-day reset on Jesse Orozco, please. All right, we'll be back on August 14th
All right, thanks.
and state will tender an offer. Oh, don't leave until you get the reset form. Just have a seat. Who's here on Adrian Holmes? And where's Mr. Holmes?
He's right.
Come down. I'm so sorry. There's a report that's due, but our system is down, so I can't see
Got
it.
an update for you.
Okay, yes.
I stopped by Judge Rodriguez this morning and they told me that the evaluation is scheduled for August 21st. And I think I've got a date in your court in September already on the computer. I haven't-
Okay,
Didn't sign anything for it. I think it's September 7th.
all right. Mr. Holmes? Yes.
It's working for me.
Oh, it's working now? Oh, thank you.
I think it might be more.
All right, let me see. All right, Mr. Holmes, I'm so sorry that it's taking so long to do the evaluation. We have a limited amount of doctors to hear cases. And sometimes the pay for the doctors is not sufficient for what they do. So many times doctors will do some of these cases as pro bono. I'm sorry, just one second. Yes, so many times doctors will take these cases as a part of their clinicals and they won't charge. But we have a limited amount of doctors in Bexar County, so the soonest we can have you evaluated according to the court that is in charge of the evaluations is August 21st. So we do have a prior setting for you in this court so that I can make sure that we stay on top of your settings. Oh, here it is. Okay, let me see. Ta-da! Thank you, Rick. I'm sorry.
Right now, can I have my time proceeding to I was referring to this at the time, sir.
Oh, well, here's the problem. Because of the nature of your offense too, and also legally, once there has been raised an issue of competency, you have to follow through with the competency evaluation. So legally, there's nothing I can do.
The doctors advocates, I mean, their doctor association.
Hmm?
It's about the doctor association, excuse me, I just looked at. Yeah. Okay.
All right, so this is what I'm gonna do. Norma, he's scheduled for an evaluation on August 21st. Can you just recall this after August 21st, please?
No, I'm gonna miss the appointment.
I looked on the computer last night and I think it said we had already had a date for September 2nd.
Now, September 2nd, that may be, let me check.
Okay.
Yes, so that's not for this court.
Yeah, the court said they have 30 days to get the report in once it's the evaluation's done. So-
All right, so this is what I'm gonna do. I'm gonna recall this, Norma, if you can give me a date later in August, please. so that we can make sure the evaluation actually happened. Are you available on the 25th? All right, so we'll come back on August 25th.
Thank you.
All right, do you have any questions, sir?
How long has I've been, doing? And, yeah. August 25th.
Thursday we'll come back here.
I'm thinking I was hoping that next time, sir.
I think he had a question about credit, jail credit.
So here's,
If and when your case gets resolved. If and when your case gets resolved, hang on, you're getting credit for all the time you locked up. Okay, so you just.
all right, Mr. Holmes? Mr. Holmes, what I can tell you is what you're charged with, the range of punishment for that offense is 2 to 20 years. So the time that you're in custody, go towards the 2 years if that's some sort of an agreement that is reached. Okay, all right. All right, Juan Aguilar. Thank you.
This is a case on requesting a plea deadline, we'll be on the discovery.
Okay,
I believe I've received all the discovery.
okay, it's set for a plea deadline today.
I'm born, judge said, discovery.
All right,
That's my
that,
request form was.
all right, that's incorrect, but what we'll do is I will set it for a another plea deadline date. How old are you, sir?
I'm 26 now.
All right, Ms. Ferguson. If we can recall this back in 2 weeks for a plea deadline date, please. Is that good for you? July 29th?
Can we come to 30th, since I'm here on that other case?
Yes, we can put it on the 30th. We already have, I know, we already have 2 cases on there. I know, I'm so sorry. Yes. See, you know what? Give a mouse a cookie. He's gonna want a glass of milk.
Pretty much.
That is so true. You know, I didn't know that saying until I got that book for my niece. And I was like, oh my goodness. All right, so once you sign the reset form, you are excused. All right, thank you.
Thank you.
Number, what page is he on? Thank you. Who's here on Lamone? All right, on this case, where are we on discovery, counsel?
On discovery, Judge, believe it to be sufficient. I know it just got indicted recently. His first court date, I guess, is scheduled for August. However, I think we're here for the compliance hearing with regard to pretrial violation report.
All right, does anybody have a pretrial violation report on Lamone? No, I have nothing attached. This is all I have.
Oh,
Thank you. All right, have you had a chance to confer with the state?
yes, Your Honor. I did confer with Mr. Pitlock, and that brought to their attention the concerns of pretrial services. I actually spoke with Officer Grosso yesterday as well, Judge, and I know there has been some positives, Brax. My client did admit to pretrial services that he did have a relapse. Unfortunately, he did recently suffer the loss of his father 2 weeks ago, and that was a stressor for him. He is a veteran, Judge, and he has been seeing VA, so he's being seen a doctor with the VA, and he does have a scheduled appointment this Thursday. Since he is already set up with the VA, and he does have some issues that he's dealing with, Judge, we wanted to see if this court would entertain doing a referral for veteran treatment court. I did notify him on the outside of the door that there is that screenshot where you can take and get more information. So he has been looking into that, Your Honor. But I do think that would be a possible good resolution to get him set up with that treatment, veteran treatment court, since he is dealing with some things and currently set up with the VA. So I did speak about with that idea with the states about addressing this and moving forward in terms of potential treatment response. And they seemed on board with that possible route if he does qualify for that program.
All right, so you're not allowed to drink alcohol. Do you understand?
Yes, Your Honor.
All right, so this is what the court is gonna do. I'm gonna order that you be continued on the PAM device. There's still no driving. I'm asking that the fees be waived, and you're gonna do 90 sober meetings in 90 days. Do you understand?
Yes, Your Honor.
Here's the thing. With these sober meetings, if there's an issue and you feel that you're going to use or there are stresses in your life, that's when you need to contact the VA. That's when you need to contact whoever your sponsor is. Do you understand?
Yes, Your Honor.
And I'm gonna put it in this order so they'll know. We'll do a referral to veterans treatment.
Thank you.
All right, and Norma, on this case, could you do a referral to felony drug court? Tell them that his case is still open. Veterans Treatment Court. And can I have a 30-day reset? All right, we'll be back on August 14th.
Thank you, Your Honor.
All right, thank you. Once you sign the reset form, you are excused, and make sure you follow through on everything. You understand?
Thank you, ma'am.
You're welcome. Who is here? Xavier Chamberlain.
Mr. Chamberlain?
And counsel, do you have witnesses?
No, Your Honor.
All right. Court is calling 2025 CR 0000069, State versus Xavier Chamberlain. Could I have parties announced?
Rick Daniels for the state of Texas.
Renee Munoz on behalf of Mr. Chamberlain.
And are you Mr. Chamberlain?
Good morning, Your Honor. Yes, ma'am.
All right, according to the plea bargain agreement, just 1 second, we'll wait till they're finished over here. All right, you entered a plea on May 27th of no contest to assault a family household member with a previous conviction. According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years. This is to run concurrent with 2025 CR 0000071, 2025 CR 0000092. Those cause numbers, have you been sentenced on those or those motions to revoke?
They're all new cases that got indicted. He doesn't have any pending motions to revoke. It's just, there was a plea on as to some and then summary BTIC to resolve.
All right. All right, have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections?
No objection by the defense.
No, well, I'm silent, but I'd just like to speak.
All right. All right, do you have any witnesses?
No, Your Honor, just, I believe, just a procedural background, justification as to what we believe is an appropriate course of action that we would ask the court to follow.
All right,
as
just
well
one
as-
second. State, any witnesses?
None from the state.
All right, then you may proceed.
Thank you, Your Honor. In reference to Mr. Chamberlain, I have been on his case, ever since he got picked up on these offenses in October. I've met with him routinely, and this is an individual that I believe is grappling in with drug addiction and does not have an innate sense of criminality, Your Honor. Ever since he's been in pending custody in the Bexar County Jail, he has done family violence individual counseling. I have those forms here, if I may show the court.
Any objection?
None from the state.
And so he has been working on those things. He has been learning about boundaries and effective ways to deal with stressors in his life as well, to not take him out in a violent way, Judge. There's some cases pending here, but if the court does take note, one of the offenses, there was no bodily injuries observed by law enforcement, and the other one, there was a small, slight little scratch. In dealing with the case and talking about the evidence and our avenues for taking this in front of the court in terms of sentencing, we did talk about certain inconsistencies within some of the reports, but that was more so before he accepted the plea. So he does accept responsibility. He knows that he messed up. He knows that this was a toxic relationship with an ex that he shouldn't have been continuing, but he was in the midst of drug addiction. As noted in the PSI, he was under the influence of drugs at the time of these offenses, Judge. Also in the PSI, he has never had residential treatments. He has had outpatient treatment before, but because we believe that his needs are severe in terms of his daily methamphetamine usage before he got picked up, we feel like inpatient treatment would be more so suitable for him to get a grasp on his issues that he's dealing with. We're looking, Your Honor, in terms of his whole life and his future down the road. And in terms of serving the community and also helping Mr. Chamberlain work towards bettering himself, we feel that inpatient treatment would be more conducive in that we're able to address the root cause of this and hopefully put a stop to this from ever occurring again. If Mr. Chamberlain is institutionalized or incarcerated without the proper form of treatment, we feel that we may just be repeating this pattern of events that has been going on. Mr. Chamberlain has been to prison before, Your Honor, but this was about 20 years ago. When he was younger, did not get the appropriate treatment. He was essentially sent to TDC, released out, and had been battling homelessness as well as drug abuse. For these reasons, Your Honor, we're requesting a period of a deferred adjudication as long as the court sees fit with inpatient treatments. And I did speak about if the court did approve inpatient treatment, what that would be looking like in terms of transfer to a facility and then having to be compliant with the terms of community supervision thereafter. Before Mr. Chamberlain was picked up on this offense, he did start school at St. Philip's College. He was about 1 month into that program until he got picked up on this offense and did not have the opportunity to bond out. But he had been working towards his HVAC certification, where he wanted to work in that capacity in terms of a career for himself, Judge. So in looking at his criminal history, he does have minor things such as theft, drug possession, a burglary. These are all things that I think were tied with drug addiction, drug usage. So we're asking that the court take a look to see if he's eligible to address the root cause of that addiction to stop this cycle of institutionalization.
All right, is there anything you wish to say, sir?
Yes, ma'am.
You want to raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
David Chamberlain.
All right, you may proceed. What would you like to say?
Your Honor, I take full accountability for my actions and I'm very remorseful, but at the same time, I know that I
learned a lot from this experience. I'm not the same person I was a year ago. I just want to move forward in my life and just be a better person for my family, for members of my community, and just get past this and just move forward. I'm too old to be making mistakes and
But the question is, why do you, I mean, these are not mistakes, these are choices. Why do you keep making the same choices? Because you have previous convictions for assaultive behavior. That's why this is a assault with a second conviction. So why do you keep making these same decisions? And then we have the violation of protective order. So there's a protective order in place. And when people violate protective orders, those are court orders. So that tells the court if you're violating that, then you won't follow my orders because you're already violating a court's order.
I was under the influence of drugs and I
I'm
just,
sorry,
I
what?
was under the influence of narcotics, Your Honor, and I'm just trying to see opportunity for treatment.
But I mean, yeah, you're under the influence of narcotics, but it didn't stop you from going to the location of the complainant and striking the complainant.
I was living there, Your Honor.
But wasn't there a protective order for you not to be at that location?
Not to my knowledge, and not until I was arrested was I informed of the protective order. My ex never told me about it.
Okay. All right, is there anything else? And on this case, what I can tell you, I don't have the trial court certification of defendant's rights to appeal. I know you probably filed it, but it's lost somewhere. So if you could do another one for me, please?
Yes, Judge, would that be one I have to get from them, or do they have them on? the
They
wall?
should have them on the wall now.
Yes.
He took the last one.
Oh.
The clerks
Yeah,
may
be
have
quick,
some
man.
more. All right, the cause number is 2025 CR 00069.
Things go like hotcakes, Your Honor, these nice ones.
Oh, yeah.
They're custody. They repeat this, and this is just a formality of the. Wow. What's that? The honor, can we tender it?
Yes, thank you. All right, any further witnesses?
None from the state. None from the defense, Your Honor.
All right, so Mr. Chamberlain, I want you to know your attorney did a very good job for you because you have numerous cases that are open and pending, right?
That's right.
I just don't think that you're a good candidate for probation. So I'm going to find you guilty. There's an affirmative finding of family violence. There's to be no contact with the complainant. A $1,500 fine, time and money to run concurrently. This will run concurrent with 2025 CR 00071, 2025 CR 00092. Take in consideration 2025 CR 00070, 2025 AL 002118. Court will give you credit for any time served, the therapeutic community, and 5 years in the prison. With the therapeutic community, I have no jurisdiction to mandate that you be in the program, but they'll know in the judgment that I'm requesting the therapeutic community for you. So there may be either mental health issues or drug issues. You're still going to have to request the program. You understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
That's right.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
That's right.
All right, we can go off the record. So here's the thing. When you are released from the prison, if you can't find a place that can help you with your addictions, you can always come back to here. If I'm here, then I will see if we can find a placement for you, okay?
Thank you.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. And if y'all can see what's gonna happen with the remaining cases, please.
Yes, Your Honor, I would definitely check up on that.
All right, thank you. The court is calling Joseph Joshua Harris. Where are you?
Good morning.
Good morning. So where are we on discovery?
Judge, it's something that I might have, well, I want to bring up to the court.
I just- this. And we will see what we're going to do, okay?
Okay.
All right, so Ms. Ferguson, on this case, can I get a 30-day reset? And we may end up bringing you back sooner than this, but this is just to give the court more time and the state and your counsel more time to confer with each other.
Okay.
Yes, ma'am.
All right, so we'll be back on August 14th. All right, thank you.
Thank you.
Who's here on Johnny Galvan?
Here for Mr. Garcia.
Yes. And Mr. Galvan? Come down, please. How's he doing?
The secret doctor who is now referred to.
Let me ask you this. Who's appointed on these cases? Would you like to be appointed on these since?
If that's fine, Judge, if that helps you, that's.
Well, I mean, so that his client.
For this particular, but the other who's up there as well, Pedro Rodriguez, he's hired, so he's hired on that one.
Yeah. All right, and this one is appointed, correct?
Correct.
All right, Norma, on this case, could you put Ms. Christian down as co-counsel?
Perfect.
All right, so what I'm gonna do, your attorney is ill, right? So I'm gonna recall this for discovery, so this attorney can get up to speed on everything.
Yes, ma'am.
All right, Norma, if I can have 3 weeks on each of these, please.
I think on Mr. Rodriguez's case, he just wanted it set for trial. But
All right,
however
well,
you want to do it. August 5th.
all right, it's gonna be August 5th. State on Johnny Galvan on August 5th. You'll need to be prepared to tender an offer.
Yes, Judge.
All right, Mr. Galvan, I see you're a Padres fan. All right, so they're gonna take you back unless you have anything else to discuss.
No, and then I'll check out that discovery and I'll make something happen.
All right. All right, sir, you can have a seat back in the box. And then who's the other person?
The other one is Pedro Rodriguez.
All right, Pedro Rodriguez. All right, what I'm gonna do with this case, your attorney is ill, counsel. I'm just gonna put this as August 5th as well, so maybe you can have an update for us.
I definitely will do that, Judge. But if you'd rather, he just asked me to set it for a trial setting, if that makes it more expeditious. Either way you want to do it.
Well, let's do an update
Okay, got it.
on that date, and then after that, I'll do your trial set.
Perfect.
So on August 5th, we're gonna come back for this case with an update on counsel's health,
Okay, yes, sir.
because I don't want to set it for a jury trial date if he
Gotcha.
has
Yeah.
more time than he's gonna be
Okay.
out.
No worries.
Is that the same page?
Yes.
Yes.
And what page is he on?
He's on the first page.
Thank you.
And so you guys are good on?
Yes. All right, thank you.
Thank you, Judge.
Thank you, Judge.
You're welcome. All right, John Anthony Robles. And are these applications or not?
No, Judge.
Okay. Court is calling 2025 CR 006650, 2025 CR 006653, State versus John Anthony Robles. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor, and Brandon Jackson for John Douglas.
And are you Mr. Robles?
Yes, Your Honor.
Counsel, have you received all discovery that you reviewed with your client?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Robles, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, in the cause number ending in 50, are you proceeding on the indictment as presented?
No, Your Honor, the state is waiving and abandoning the repeat offender enhancement.
Any objection?
No objection, Your Honor.
And in the cause number ending in 53, are you proceeding on the indictment as presented?
No, Your Honor, the state is also waiving and abandoning the repeat offender enhancement.
And no objection, Your Honor.
All right, Mr. Robles, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in each offense you're charged with theft of property less than $2,500 with 2 or more previous convictions? As state jail felonies, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering these pleas, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Robles, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. The state is waiving the enhancement paragraphs. There are no applications. The cases will run concurrently and there's to be no contact with the complainants. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There are not, Judge.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and all attachments in both cases respectively are on.
No objection, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you agree the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments and each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, I just respectfully ask that you follow the agreement. He's ready to get on with his life. He said he's done with this type of life and ready to move forward.
All right. And the cause number ending in 5-3. The court will follow your agreement, sentence you to 1 year in the state jail facility, give you credit for any time served. This is run concurrent with 2025 CR 006650. And there's to be no contact with target. And I'll request the therapeutic community. And the cause number ending in 50. The court, as previously stated, is finding you guilty. The court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 006653. There's to be no contact with China King Buffet. And I request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. If you continue doing what you're doing, only one or two things going to end up happening. You're going to end up spending the rest of your life in prison, or somebody may end up killing you because you're stealing. And this is Texas, okay? All right, good luck to you, sir. All right, Jorge Jimenez. Who's the person for her? Is the attorney for Jorge Jimenez here? Okay. Mahmoud Al-Gadrab. The attorney for I'm sorry, sir, your attorney's not here.
Oh.
Mahmoud Al-Gadrab, who's the attorney? All right. Enrique Talamontes Segura.
Sure, President.
All right, if you'll come down, please.
I'm on this. Yeah, keep following.
No, I don't have Escobedo's file. It should be up there. All right, so we're set today for discovery. Are there still discovery issues? Need an interpreter?
Yes, Your Honor.
Okay.
Good morning.
Good morning.
I was ready for the other case, so.
Oh, that's okay. It's a crazy Tuesday, but it feels like it's Monday.
I know. Ready.
Hello. All right, so counsel, we're here for discovery. Where are we on discovery?
Yes, Judge. So on these 3 cases, I submitted 3 respective motions for discovery on this case.
All right, it's 3 cases?
Yes, Your Honor. Well, yes.
Okay, I only have 2, but okay. All right, you may proceed.
The state gave me some additional, well, an affidavit for search warrant, Judge. And so I believe, based on what I read, the only discovery that I would need is, if the state has it, is the surveillance video from essentially some drones that were on the property when this incident occurred.
All right, and guys, Talamontes Segura has 3 cases. I only have 2. All right, are all of these cases alleged to happen on the same day?
Yes, Your Honor.
So there will be drones, potentially drones in everyone?
Yes, Your Honor.
I believe a lot of this is uploaded to the Veritas and that's where I got the search warrant from, so I don't know if you kind of said opportunity to do that or not, so some of it should be there. That's what that.
Yeah, we've received a lot of discovery. Judge, I've gone through some of the videos, body worn cameras, dash cams. I haven't seen the drone video yet, but I'll look for it. And if I can't find it, I'll let Jason know.
All right, so what we'll do is we'll reset this for 30 days for one more discovery setting. I need a 30-day reset for discovery. All right, August 14th. And is your client a citizen?
No, Your Honor.
Does he need an immigration attorney appointed?
Yes, Your Honor.
All right, so Norma, we need immigration attorney from MAC on this one.
Yes, I'll do it. Of course. Yeah, I'll get that done today, Judge.
All right, thank you. Is there anything else?
Nothing further from defense, Judge.
All right, and Mr. Segura, is there anything else?
No.
All right, thank you.
Thank you.
Thank you.
Good night.
Who's here on Cameron Scott?
Mrs. Scott.
Yes. Are you okay, Mr. Cox? Do you need a cough drop? We've learned to keep cough drops. Oh, okay. All right. Let me pull him up.
Motion for early termination.
Ah, yes. All right, State, do you have witnesses?
Your Honor, I do believe this is the second attorney on this case. The previous defense attorney had agreed to let our complainant testify by Zoom. My understanding is that Mr. Cox would be objecting.
All right.
I would like to.
All right, so we'll reset it and then we'll need the complainant present.
Yes, sir.
All right, so how much time do you need to have your witness?
Your Honor, if I could just check with her and see when she's available.
Okay. All right. So if y'all have a seat.
Could you look back to me? But I attached an email of the regarding this about.
There's no email. Things are disappearing. All right, Jose Sanchez. Court is calling 2025 CR 005279 State versus Jose Luis Sanchez. Could I have parties announced?
Megan Galloway for the state.
Albert Chavez for Mr. Sanchez.
And are you Mr. Sanchez?
Yes.
All right, we have an interpreter here. Could you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right. Counsel, do you speak Spanish?
I do.
Do you speak it fluently?
Yes, I do.
And were you able to review these documents in Spanish with your client?
Yes, I was.
Mr. Sanchez, all of the documents I'm going to review with you are in English. Were those documents reviewed with you in Spanish?
Yes.
Mr. I'm sorry, there are no applications?
No,
Okay. Counsel, have you received all discovery? Did you review it with your client?
we did.
Court will find that the state is in compliance with discovery. Mr. Sanchez, did you review the true bill of indictment with your attorney? Did you understand it?
Sí, yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Right. Mr. Sanchez, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
You're charged with driving while intoxicated third or more as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea in this case?
yes,
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no,
Anyone promise you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 5 years in the prison. This will run concurrent with 2019 DCR 01247E. And there should be $60 to DPS for testing. Did you understand that to be the plea?
yes,
Defense, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
no,
This paragraph here in the document, the waiver of appeal paragraph, did your attorney review that with you?
yes,
All right, did you sign it?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counselor, are there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead?
This courtroom session quickly turns into controlled chaos, not because of the people, but because the entire system breaks down. As the hearing begins, the judge immediately warns everyone the digital system Odyssey isn't working and there's no backup plan. What follows is a mix of frustration, sarcasm, and strict courtroom control. The judge makes it clear everyone needs patience. Files are missing, processes are delayed, and even basic case handling becomes difficult. At one point, the judge openly calls out the system failure, saying nobody planned for this situation, forcing the court to go old school with paper files. Despite the technical mess, the courtroom doesn't slow down. Cases continue one by one. Defendants are called, attorneys scramble to locate documents, and the judge maintains authority throughout. Some defendants are warned about being late, others are told to take their cases seriously, and one even gets called out for inappropriate behavior in court. There are moments of tension, but also sharp reminders: follow the rules, be respectful, and come prepared. Even when everything behind the scenes is failing, the judge keeps the courtroom running with discipline. In the end, this hearing becomes less about the cases and more about how the justice system holds together under pressure. Even without technology, the courtroom doesn't stop.